So the gag order says that can't talk about the individual prosecutors, their families and staff. Can't talk about the court staff. Judge didn't say he couldn't talk about the judge. And then was kind of vague on what she was going to say about witnesses. So we'll see what the written order looks like. But there's absolutely no basis for this prior restraint. There just isn't. So as conditions of release, you can't intimidate witnesses. And, of course, it's already a crime to intimidate witnesses. So you can't issue prior restraint on that basis. But you definitely can't do it because the prosecutors don't like people talking about them. Or the judges. These are public officials. And their staff. Clerks have long got away with this. Marshals, other people, court staff, bailiffs. A lot of them are as corrupt as heck. And they get away with no scrutiny to what they're doing and what they're up to. There's no constitutional basis for it whatsoever. No prior restraint basis for it whatsoever. Neither she nor the government, to my knowledge, cited a single court case that supported what the order was that they issued today. All it did was give Trump political ammunition and give a basis to appeal and further evidence that she's incurably prejudiced. Now, credit to Senator Vance, who's the first one that I know of to publicly say this judge should be impeached. Finally we're starting to see some elected representatives make public statements about this nonsense. There needs to be political consequence. I mean, here's a judge abusing her power, threatening a defendant and his lawyers that if they do anything to block her attempts to interfere in the election, that she will personally punish them and exercise judicial power to do so. That's abuse of office. It's abuse of judicial power. She has no constitutional prerogative to do. That's an impeachable offense in my view. If you buy Jack Smith's theory, it's a federal crime. So what the judge is doing. So I thought the Trump people argued pretty well in court. The only thing I just never accept, too many lawyers accept the idea when a judge says, well, you agree that, like you agree, they can't make comments like this about a prosecutor. Heck, yes, they can. Absolutely. In Gentile versus the State Bar of Nevada, I've been in courts making this exact argument because I've either had opposing counsel come after me or I've represented lawyers who the opposing counsel was coming after. And I'll often get this, and the judges will often be shocked. They're like, really? It's like, dear God, read the Constitution you take an oath to next time. There's nothing in there that says you have a special prerogative under the First Amendment to protect the precious reputation of the judge or his clerks or his staff or his employees. They are public employees paid for by the American taxpayer. They get to be outed like everybody else, publicly discussed like everybody else. And if they're doing questionable behavior or have questionable biases that suggest they should not be in that job, they should be exposed and condemned for it. There needs to be more public criticism of judges, not less. More public criticism of law clerks, not less. More public criticism of court clerks, not less. More public criticism of bailiffs, not less. I've had 3 cases in which bailiffs deliberately interfered and corrupted and obstructed justice. And if they had done it on behalf of a defendant, they would be in prison. But because they did it on behalf of a corporate law firm, or they did it on behalf of the government, nothing of consequence happened to them, and judges would go berserk when I raised the issue. In one case, a United States Marshal, who served as bailiff in a proceeding, along with the court clerk, along with all the law clerks and his staff, conspired to improperly communicate with the jury outside of my presence and without my knowledge. Patent violation of the law. If I'd done anything like that, I'd have been disbarred and imprisoned within days. But here, a federal judge ordered it. Law clerks knew about it, didn't say boo. Court clerk knew about it, didn't say boo. United States Marshal, bailiff, didn't say boo. And I happen to like the Marshal. He was a nice guy. But what he sees a judge see do corrupt action, what does he do? Covers up for the judge. Facilitates the corrupt action. Then you had in another case, the bailiff for the judge interfering with the jury, telling the jury who was objecting to who. And for example, what we had was a jury where jurors were falling asleep during the trial, badly. And I was like, this is garbage. And raised it with the court. It's supposed to be anonymous which counsel raises it. The judge does an inquiry, decided to keep that juror on the jury. And as soon as the juror came back in, she stared right at us, and I knew why. The bailiff had been talking to her and told her which side was which. Bailiffs often have exclusive monopoly access to juries. They hear things all the time, and I guarantee you they report them to the courts or the government. They usually just keep you in the dark. Now and then they'll hint at these kind of things to you here and there. They'll tell you, oh, don't take a long lunch break. Jury's going to be back probably pretty quickly. Right. Oh, okay. That means you already know what the jury's been deliberating before deliberations occurred. Wonder if you were sharing that information with anybody else. I've met very few honest and honorable bailiffs and clerks in my experience, to be blunt about it. The court clerk in the Wesley Snipes case was a corrupt hack who was dismissing jurors on illegal grounds without the presence of counsel or the court even dismissing the jurors. It told a juror who came back in, oh, you're dismissed. Wasn't dismissed. It was a juror who was going to be favorable to the Snipes defense. And then told the judge, oh, he called in sick. He didn't call in sick. He showed up. She just told him to go home. He had been dismissed. Deliberately. Do you think the judge did anything about it? Of course not. Think the prosecutor did anything about it? Of course not. So they cover up for corruption and fraud by their court staff, who sometimes are the most critical, corrupt actors in the entire courtroom. Had another case when the bailiff was clearly communicating illicit information to the jury, clearly didn't like us, was friends with the corporate law firm that often was there. We had a big corporate law firm defending another big corporate law firm, right? So, it was like combo corporate law firm day. And I was representing a family suing them. And it was clear to me that the bailiff had communicated improperly to the jury, improper information. Basically, the bailiff tried to suggest that my jury consultant was spying on the jury. It's totally false. My jury consultant had eye problems, so when she was looking at her phone or something else, she had to look like this. They thought she was secretly recording it. It's complete garbage. But it was from the bailiff. But you think the judge wanted to hear anything about that? He'd go berserk. He'd take my head off first. So this is exactly who the world should be talking about, who lawyers should be talking about, who defendants should be talking about. And to issue a gag order, a prior restraint, prohibiting the speech under criminal punishment, under criminal penalty, if you go out there and talk about any issues of potential corruption involving the court clerks, the court staff, court personnel, the prosecutor's staff. The idea, they have absolutely no power to do that. It's the most horrendous use of a gag order. And it interferes with the election on top of it. In Gentile versus State Bar of Nevada, when the U.S. Supreme Court said you couldn't even sanction a lawyer, and remember, an individual, non-lawyer, doesn't have any of the ethical restraints that a lawyer has. So an individual even has more speech rights than a lawyer has. They said that you couldn't even discipline a lawyer after the fact, least of all impose prior restraint. Because remember, again, after the fact penalties are a lesser standard than prior restraint. Prior restraint is almost always prohibited by the courts for lots of good reasons. You remember, the U.S. Supreme Court said you couldn't issue prior restraint on secretly leaked documents about an ongoing war that directly impacted national security. If that isn't grounds for prior restraint, how the heck is covering up for judicial corruption grounds for prior restraint? Covering up for prosecutorial corruption grounds for prior restraint? Covering up for witness lying grounds for prior restraint? Preposterous. So but what happened in Gentile versus State Bar of Nevada is the defense attorney went out 6 months before trial and said, by the way, the grand jury is corrupt, the judge is corrupt, the prosecutor's corrupt, the agents are corrupt, the witnesses are corrupt, they're all conspiring to commit perjury and fraud in order to put my client in prison. And they said you couldn't even punish a lawyer after the fact. Much lower standard for the government than they have to meet for prior restraint of an individual defendant. This judge doesn't even get close to it. The only mistake, or the only, I don't say mistake, but where they could have been more robust, always push back on that crap. There's no special decorum for the court. No, you're a public official. You're on the public payroll. You took an oath, and you should embrace transparency. You should want and embrace public criticism so people don't think you're covering something up, Judge. You wouldn't want that impression, would you? That's how you push back on that nonsense. So I assume Trump will appeal it. He already said he will. I hope some third parties intervene on the grounds that they want to hear from Trump on these issues. They want to hear from Trump's counsel on these issues. They have a right under federal law, under constitutional law, under the local rules of the D.C. federal court to intervene and seek it out. I hope Julie Kelly or somebody else does, because they have independent rights to access to that information and hammer this home. So we'll see how that goes. It does reveal the escalating risk that the judiciary will fail to step into the breach and preclude the death of American constitutional democracy, or constitutional republic, call it what you will. And increasing risk that they'll actually intervene and impair and impede the election in 2024 with things like gag orders, with things like imprisonment, with things like trying to take Trump off the ballot. So and that's why people that are all worried about what happens on Election Day with Robert Kennedy are missing the boat, just missing the boat badly. Don't understand the greater risk is Trump not being on the ballot, is Trump being in prison, is Trump being prohibited from speaking. That's the bigger risk. And you need a backup plan. You need a deterrent to them doing that. And Robert Kennedy being on the ballot is a very good deterrent to that. And everybody's obsessed over something that may never come about because they're putting their priorities in the wrong order.